seen it.
Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome to Talk Law Radio. I'm Todd Marquardt here with attorney Ed Marvin and attorney Shannon Roberta San Antonio Salomon Haas. We're talking about copyright law, and now we're going to be talking about artificial intelligence. The reason I invited you on the show, Ed, is because I think this is a hidden legal issue blind spot for authors and painters and musicians and inventors. How can they protect themselves from AI, or do they need protection from AI and artificial intelligence? And I thought this Urantia book case would be a fun way of sort of just talking about copyright law. So I think to set the stage, we need to know how, if I write something, how do I protect my writing? Or if I do a YouTube video, how do I protect, my video? Do I have to register it, or is it already protected automatically by common law?
Okay, it's a great question. So the answer is you are protected. You do not have to register your copyright in order to have the protection. However, big caveat: if you ever have to go enforce your rights, somebody has copied your writing, you will have to register it, because having a registered copyright is a prerequisite to bringing a copyright infringement suit. Supreme Court decided that decision a few years ago. And there's other incentives to register your work. I mean, I highly recommend registering your works, provided that they rise to the level of being creative enough to be registered. The other incentive is the statutory damages and attorney's fees. So if you do have to go enforce, you believe they're infringing your copyright, if you have not registered your work at the time that the infringement commences, you have given up your ability to get your attorney's fees or statutory damages in the lawsuit. Okay, so now what that means is you can still bring the lawsuit. You can still get it registered and bring the lawsuit, but you're going to have to prove your actual damages, which can oftentimes be very difficult to prove in a copyright infringement context. And you've also given up your ability to seek your fees, your attorney's fees. So now, even if you prevail, depending on what you pay your attorneys to go win, you might be at a net loss. So highly, highly recommend registering your copyright to protect yourself, in the event that you reach that situation. And candidly, it's not, the fees for registering are not terribly bad. I think it's $65 or something like that in government filing fees. It's not terribly expensive.
Oh, okay. How interesting.
Okay, as we transition now to artificial intelligence, Shannon was telling me that the judges nowadays have to have special training so that they don't just automatically rely on video as evidence, because it could be altered video or it could be an altered audio statement. And so I found this publication, An Introduction to Artificial Intelligence for Federal Judges.
Right.
And I really liked it because it breaks things down so
simply. It was 102
simply.
pages long.
Well, I'm just going to start at the beginning.
But it was good. It was good stuff.
So I wanted to find out, what is AI? What are they telling federal judges?
Right.
What is artificial intelligence? It says AI is not a single piece of hardware or software, but rather a constellation of technologies that gives a computer system the ability to solve problems and to perform tasks that would otherwise require human intelligence. Are you receiving so much education on AI in your field of law?
Yes, and we're seeing just a ton of cases. This really is the cutting edge when it comes to copyright infringement, and you really see it from two aspects. Number one is artificial intelligence created works, do they rise to the level of being copyrightable?
Let me stop you there. I went to an estate planning attorney conference, and there's this guy there that says that we should write our own books and do the whole thing with AI. And, just put in some prompts, tell AI what you want the book to be about, and then hit go and then just publish it. But I worry about that because AI, at least in my mind, what I think AI is doing, it's just scraping information from other places that might already have a copyright. And so years down the road, somebody's going to knock on my door with a lawsuit and say, you published a book based on my writing.
Yeah, I think your mind is right on that, Todd, but we're not quite there yet.
Okay.
Right now, when in the infringement context, what we're seeing is the companies that provide the AI being sued for copyright infringement because they've created copies of pre-existing works to train the AI model.
Okay.
Right. So, just the other day, for example, there's a case that I saw, talking about, and this was earlier this week. I mean, artificial intelligence, Thomson Reuters, the people that put out the Westlaw that we use in our legal research,
right,
had sued somebody because they were creating a competitive legal research platform, and they were using, what they did is they pulled a bunch of the Westlaw head notes or case notes that we're familiar with when we do our research. They had pulled that to train their own legal research database, right? So right now, where the lawsuits are with respect to infringement is really on the training of the AI so that it can generate the outputs that you're talking about with your estate planning book.
Right.
I think where your gut is where it will go eventually, right? But I just don't think we're there yet.
Yeah. So I still think it's important for people to use their own mind, create their own ideas, and then put that down on paper and not rely so much on AI.
Could he get a copyright on that book if 99% of it was AI generated?
Probably not. The Copyright Office, they just put out. I mean, and like I said, I mean this is cutting edge stuff. Just this last month in January, the Copyright Office put out kind of its statement, its positional statement as to whether or not artificial intelligence generated works were copyrightable, and the answer is no, because they're not created by humans. Okay, but it gets tricky because Todd, you indicate the inputs, right? How much of what questions did you ask after you got the content that was generated by the artificial intelligence? Did you then use your own mind, your own mind to edit it, to change it, and how much of that did you do? Because in order to be an author, and this is the Copyright Office's position on this,
right?
And the courts are agreeing. In order to be an author, you have to be a human. You can't, artificial intelligence is not a human, and therefore not considered an author under the Copyright Act. And so when you say if 99% of it was created by AI, then I would say probably you're not going to be able to get a copyright protection.
But if he wrote
work.
the words and maybe got the pictures from AI generated images, or maybe they'll get into the weeds like that, like 48% of it was...
Here's an interesting story.
Yeah.
I was listening to a podcast about an author that was talking about AI, and she writes fictional stories. And so she said, I wanted to really know what it was like to be the character that I was creating. And so I told AI to have a conversation with me from somebody that lives in this country and that shares these characteristics.
Oh, wow.
And then like the prompt became like this other character.
Wow.
And the way it was
interacting. Wow, that's amazing.
And something else that's funny that's related to rodeo and the hat.
Yeah.
My brother asked Chat, what kind of hat should I get? And, it said various hats. And then he asked Chat, are you a white hat cowboy or a black hat cowboy? And it said it's a white hat cowboy because it wants to help you.
Okay.
I don't know. I just thought that was silly.
Okay.
But you were
if it was a black hat cowboy, that's exactly what it would say, is I'm a white hat cowboy.
That's true. Yeah, covertly. Ed, you were talking about the difference between a human author and a non-human author. And I think that brings in our discussion on Urantia book. And so in this saga over this book, let me see if I can succinctly talk about it. There was a psychiatrist that had a patient who said that he was communicating with people from another world or another universe. Well, the psychiatrist and his patient wrote down all of these stories and spiritual revelations of what they experienced, and they eventually put a book together. And somebody that really liked the book decades later just made a copy of it on a computer disk and started giving out the computer disk to people, and she got sued for copyright infringement, right? And
she was just giving it away for free.
Part of the court case was, is it copyrightable, right?
That's right. So, I mean, in order to bring in a copyright infringement action, one of the elements is you have to own a valid copyright. And then, then you have to show that it was copied. The work was copied from the original work.
Right.
And so part of the burden of proof is that they had to show that there was a valid copyright here. And of course, the defendant in the case was trying to attack that by saying there is no valid copyright, therefore you cannot sue me for copyright infringement.
Not valid because beings from another world created the work.
That's correct. But what the court ultimately held is no, there is actually some copyrightable authorship contained within this book, because the author compiled these stories that were being told by the patient, selected and arranged the stories in a fashion and in a manner that demonstrated copyrightable authorship. To be clear, the copyright protection was not in the individual stories themselves. In fact, there was an interesting part of the opinion that I kind of starred when I was reading it. It says, this case does not concern the use of a single revelation outside the context of the book, which for purposes of this case would be analogous to a fact, and which of course would not be copyrightable. So the specific revelations authored by the divine being were not considered copyrightable. They didn't have copyright protection, but it was the selection and the arrangement of the revelations that is where the protection lied. And since the defendant copied the entire book, i.e. she copied the selection and arrangement, there was infringement.
Right.
Were they basically saying, we don't believe an alien did this?
No, I don't think they even cared. No, because, and then Ed found other cases about other revelations. But we got to wrap up. We got to take a break. Stay tuned. We'll be talking about more AI.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the 10 Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.